welcome to Crime in Court. My name is Heather, and this is an update in the Karen Reed case. So, this is Commonwealth versus Karen Reed, and we also talk about Aiden Turtleboy Carney on this channel because I think they're very much, excuse me, very much interrelated, their cases, and the Commonwealth made it so. All right, so today's episode is titled episode number 48, The Commonwealth Response to Reed's SJC appeal of counts 1 and 2. So last week, very busy week, we had updates in Karen Reed trial almost every day. We had updates in Delphi as the case just started and jury selection completed. So also updates in the Menendez brothers case, all cases that I'm covering right now. So bear with me. I promised you guys this. I'm a little late on getting this and the better letters to you, but better late than never. So this is obviously we know Karen Reed is appealing counts 1 and 3 with the SJC, the uh, Supreme Judicial Court. She rightfully, I think with for reason believes that she was actually acquitted for counts 1 and 3, and at least 6 independent jury members have come forward and said so. So they filed an appeal with Judge Bev, asked her to at least bring in the jury to question them, to poll them, to find out what their actual counts were, or if they did actually come to a verdict for counts 1 and 3, and if so, did they acquit her? And if so, we need to get rid of those charges because she's acquitted. However, Judge Bev said, "Nah, I'm not going to do that because I followed the law, and any reasonable person would have understood what I was saying in my jury just instructions, which were clearly made dis, uh, to distract and confuse people when coming up with a verdict, because she failed to put in language regarding multiple verdicts and how to come to a verdict or a split verdict. She didn't give that reading. She only gave a reading for like a solo verdict regarding how they should come to a conclusion on a verdict, and then that's the only way that they can move on. But failed to leave out that there's multiple verdicts that were needed. All right, so with this, let's begin. So Karen then appealed to the SJC after Judge Bev was like, nah, I'm not going to bring in the jury. So they were able to write up a formal brief. We read through that. And now, in response to that, this is the Commonwealth's reasons why Karen Reed should absolutely be retried for charges that she was acquitted on. So here's the reasoning. I'm not going to read through probably all of it because I have a feeling it's going to make me angry. It is a 77-page document. The first 50 are the actual motion. We're probably not going to read through all of that, but we'll get through a chunk of it. So let's get started. This is obviously written by the Commonwealth. So, issues presented. The jury reported 3 times in increasingly sharper terms that it was deadlocked. Its third and final note said that the jurors remained starkly divided over the charges and further deliberations would be futile. At no point did the jury express the prospect of unanimity on any charges. Sometimes words are hard. And the defendant argued that the time that the jurors were at an impasse and hopelessly deadlocked. Did the trial judge abuse her discretion in declaring a mistrial based on the deadlock reported by the jury? So that's one question at hand. The next, the defendant did not object to the declaration of the mistrial. The judge found that defense counsel had multiple opportunities to raise an objection, and she explicitly found not credible the defendant's assertions that the mistrial was sudden and unexpected. Actually, it was. Or that defense counsel was not afforded an opportunity to be heard. Actually, they weren't. Did the judge err in concluding the defendant consented to the mistrial? Yes, I believe she did. Number 3, the next issue at hand is the jury did not return, announce, and affirm any verdicts in open court. That's because Judge Bev said, give me any, don't even tell me what your verdict is. So nobody knew that they had come to a partial verdict. And they didn't know they didn't know that they should, because they weren't instructed to, as soon as they came up with the verdict, fill out the sheet. That's what they would have been instructed to do if they had the right jury instructions regarding multiple charges, multiple verdicts, rather. So she did not give that charge. The jury did not return, announce, and affirm it in open court. Was the defendant acquitted of the charges of second-degree murder and leaving the scene? I believe she was. Let's see, the statement of case. We know all this, so blah, 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 blah. The jury trial of the 3 indictments began April 16th with Judge Canoni presiding. On June 25th of this year, the 27th day of trial, the jury began deliberating. In addition to the 3 charged offenses, the trial judge instructed the jury on 2 lesser included offenses of IOU, manslaughter, involuntary manslaughter by wanton or reckless conduct, 2, motor vehicle homicide by negligent operation while under the influence of alcohol. And on July 1st of this year, the 5th day of deliberations, the trial judge declared a mistrial based on jury deadlock. On July 8th, so 7 days later, the defendant moved to dismiss the charges of second-degree homicide and leaving the scene on double jeopardy grounds. That's because multiple jurors came out and said that they did. Sorry, I had to keep an ear out for the dog who was sunbathing. The motion was accompanied by 2 affidavits from her attorneys. The Commonwealth filed a written opposition to the motion, and the defendant filed a reply. The defendant also filed 3 supplemental memoranda. Each, is that the plural of memorandi? Like memorandum? That's the plural? I never knew that. Each accompanied by an affidavit of counsel. On August 9th, 2024, the trial judge heard argument on the motion. In a memorandum of decision and order entered on August 23rd, the judge denied the motion. She waited forever to deny it. She knew she was going to deny it anyway. She should have just done it right away. But I think she's deliberately trying to drag this out for Karen Reed and her family to suffer longer and cost them more. On September 11th of this year, the defendant filed in a county court a petition for extraordinary relief pursuant to GLC 2211-3, seeking review of the order denying her a motion to dismiss. The single justice, Elizabeth N. Dewar, reserved and reported the case without decision for determination by this court. So they were like, yeah, we want to hear this because we think they did something wrong, potentially. And this could potentially impact other cases in the future of how they are conducted. Jury deadlock, jury deadlock and mistrial. The jury began its deliberations. We already read through all of this, blah, blah, blah. On Friday, June 28th, around noon, the jury foreperson sent the first note, which said, despite our exhaustive review of the evidence and our diligent consideration of the disputed evidence, we have been unable to reach a unanimous decision. The judge asked the parties for their views on whether, at that point, the jury had engaged in due and thorough deliberations. The Commonwealth asserted that the jury had not had sufficient time to deliberate, and it was therefore too soon to give the Tui Rodriguez instruction. The Commonwealth noted that although that's the instruction that kind of pushed them to come to a verdict, even though Judge Canoni's taking it that because the defense asked for that instruction that they were pushing for a mistrial, which is actually not even close to the same thing, but okay. So the Commonwealth noted that although the jury said it and had not reached a unanimous verdict, it did not convey that doing so would not be possible. The defendant disagreed with the Commonwealth's characterization of the note. and argued that the jury was communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they are at an impasse. Defense counsel asked the judge to give the Tui Rodriguez instruction. The judge ruled there had not been due and thorough deliberations given the length of the trial and the amount of evidence presented through the 74 witnesses and 657 exhibits, the complexity of the issues, and that each of the prior days of deliberation had been shortened. She instructed the jurors to continue deliberating. They deliberated until about 4:15 p.m. when the judge released them for the weekend. And I'm going to pause it right here because I got to go close the door because my dog let herself in from her sunbathing activities. So I have to go close the door. Hold on one sec. All right, sorry about that. She has taught herself how to come in. She can open the door. I wish she could close it. All right, so deliberations. Wait, this is all, I mean, just a recap of everything that's happened. I don't think there's going to be any new arguments coming from the Commonwealth, but we'll read through and see. So deliberations resumed on Monday, July 1st, around 10:45 a.m. The jury sent the judge the following note: Judge Canoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. I feel like I've read this and heard it so many times. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point where consensus is unattainable. This bothers me. This deeply held convictions. What? Like somebody really hates drunk drivers, and because you think she was drunk, you want to punish her? So even if she didn't do it, even if the state didn't prove their case, maybe those kinds of deeply held convictions. I don't know. Maybe something along those lines. Maybe somebody who used to be a cop, perhaps, and was hit in the line of duty when he was a pedestrian on the side of his cruiser. Somebody hit him. Maybe someone who has deeply held convictions about hitting officers with their cars. I don't know. Just throwing a couple examples out there. As we know, that is the case with the jury foreman. All right, so they each carry deeply held convictions. We recognize the weight of this admission and the implications it holds. I don't think they do, but okay. Because they don't understand the cost and the time and the frustration and the anxiety and stress that it takes to go through a trial. The judge again requested argument on whether there had been due and thorough deliberation. The Commonwealth acknowledged the length of the deliberations up to that point, around 22 or 23 hours in total by its estimation, but it argued that the jury still had not conducted a thorough deliberation considering the length of the trial, voluminous evidence, and complex issues. The defendant argued it was time for the Tui Rodriguez charge, as the jury had come back now twice, indicating essentially that they are hopelessly deadlocked. Defense counsel again asked the judge to give the instruction. The judge found that the jury had engaged in due and thorough deliberation, noting the jury had been extraordinary and that she had never seen a note like this reporting it to be for them reporting that they were at an impasse. She compliments the note from the jury foreman, who she's hand selected. Just saying. She gave the jury the full Tui Rodriguez charge and deliberations resumed. At about 2:30 p.m. that same day, the jury sent another note to the judge. The parties returned to the courtroom. The case was called, and the judge informed counsel the jury is at an impasse. She didn't allow anybody to speak. At that point, the jury just started coming in. She didn't give them a chance to look at the note, which they're supposed to do. So there was just this weirdness. It was like, okay, we got a note, we're bringing them in, and everybody just sat silently. I think I don't know what everybody thought, but it was probably weird because normally judges would be like, okay, we received another note. Here's the note. Read it. This is what should we do? And then they discuss it. But that wasn't done in this case. So after the jurors entered the room, the judge read the note out loud. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. So some people think the state proved their case they far surpassed their burden of proof, which I'm like, huh? That makes no sense to me. That's why I think that this jury was compromised. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. So, again, with the convictions, which a conviction is just like a belief. So, because you hold these high beliefs, that means you're not following the law because you're being, um, maybe let's say you're against the uh, penalty that puts people in the chamber. You're against that. But, in the voir dire process, they're going to ask you, and let's say that it is a case for that. And they're going to ask you if you have any strong opinions or beliefs on that, and then that is when you disclose it during the jury voir dire process. So if these people had some moral convictions that was going to make them lean a certain way, they should have disclosed that during voir dire. This bothers me that twice now they're saying our convictions, our beliefs are so strong in this that we just won't, whatever. I I I feel like there's something there. I don't know what, but something. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. The judge told the jurors, I am not going to do that to you folks. Your service is complete. As she said that, she excused them immediately and then began, as soon as they were gone, she began scheduling back to administrative scheduling stuff on the books with Karen Reed and Lolly. So she declared a mistrial and excused them to the jury room where she said she would see them in a few minutes. The judge and what happened? She saw them. What happened in these few minutes that she saw them? What was said? Did she ask about any kind of verdict? What did she talk about? Did she say you guys made the right decision? What did she do? Like what? I want to know what happened in that room. No juror has said anything about that, and this bothers me so much that she went in there and spoke to them privately. Did she tell them not to talk? I mean, did she threaten them? I really want to know what happened in that room. Maybe it was nothing. And if it's nothing, then I want to know that too. You know what I'm saying? Like, we need to be transparent. Why did she go and talk to them privately? I just don't get it. Because most judges, as we've seen, like Judge Newman in the Murdoch case, he just flat out did his, thank you for being such great jurors. It was a pleasure working with you guys, blah blah blah. His regular thank you that he gives to every jury. He does that in the public court, not in a private room. So I just have a problem with that, especially because I don't think Canoni is um, honest. She's not an honest and truthful person, as Jen McCabe would say. All right, so B, purported post-trial juror statements. 1 week later, on July 8th, the defendant filed her motion to dismiss along with affidavits from her counsel, attorneys Alan Jackson and David Unetti. Attorney Jackson's affidavit stated that on July 2nd, a purported Juror A, contacted him. He said he was able to identify which juror they were from his conversation with them. According to Attorney Jackson's description of the conversation, Juror A said, the jury had unanimously agreed that the defendant was not guilty of second-degree homicide, and shortly following that determination, they also had unanimously agreed that she was not guilty of leaving the scene. 1 second. Sorry. So the juror A is saying that they acquitted her of counts 1 and 3. Attorney Yannetti's affidavit stated that he had received communications from two informants both on July 3rd. So this is 2 days after trial. He's already receiving, like, 1 day after trial, 2 days after trial, he's receiving more and more contacts, more and more incidents from people that are either the juror or an intermediary. So he said one of these informants, informant B, so now we've got another juror B who has an intermediary B and an informant B. Just, it's confusing, but just know there's a juror B now stepping up. So through this informant. This informant sent him a screenshot that informant B had received from some other person of the text messages that intermediary B received from Juror B. So Juror B is having a conversation with Intermediary B. Intermediary B sends the text message to Informant B. Informant B, therefore, goes to Alan Jackson or David Yannetti and says, "Look, here's a screenshot. They were talking about being a juror or whatever." Okay. So, yeah, so that's how that works. Attorney Yannetti believed he could confirm Juror B had been a deliberating juror based on the first name for Juror B given to him by Informant B. According to Attorney Yannetti's description of the screenshot, Juror B allegedly texted Intermediary B, "It was not guilty on second degree and split for half of the second charge when the judge sent us back with the Hernandez," it's supposed to be Tui Rodriguez thing, "to look at the other side. It turned into a bully match." And that is corroborated by one of the jurors that Turtle Boy interviewed on his blog. Um, and we went through it on my channel. That was corroborated that it became a bully match inside the deliberation room after the Tui Rodriguez charge was given, and then some people switched to a guilty on manslaughter verdict from there. Continuing on, it was not guilty on second degree and split half for the second charge. When the judge sent us back with the Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. That was a typo from the informant or the juror, whoever typed that. Attorney Yannetti stated that the other informant, Informant C, had contacted him to say that they personally knew a purported juror, Juror C now, so 3 jurors have come forward, or through either directly or indirectly, as they and Juror C used to work together and had a mutual friend, Intermediary C, who was a current co-worker and friend of Juror C. Informant C also knew from Intermediary C knew from Intermediary C that Juror C would be participating in a Zoom meeting with friends to discuss the trial. This was afterwards. It wasn't during it wasn't while he was on the jury, it was post jury, this person. 3 days later, Informant C sent Attorney Yannetti screenshots of text messages exchanged between Informant C and Intermediary C, in which Intermediary C purportedly reported that Juror C had allegedly said during the Zoom meeting. According to Yannetti's representation of the exchange, Intermediary C texted no consideration for homicide 2. Manslaughter started polling at 6-6 and ended deadlocked at 4 no, 8 yes, which also confirms the jury interview that Turtle Boy did, that the polling changed stronger for manslaughter after the Tui Rodriguez. Informant C texted back, "If it was no consideration for homicide 2, shouldn't she have been acquitted on that count and hung on the remaining charges?" And Intermediary C responded, "She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on. Based on the descriptions of Juror C by Informant C and Intermediary C, Attorney Yannetti said he could positively identify Juror C as a deliberating juror." On July 10th, Attorney Jackson submitted a supplemental affidavit stating that on July 8th he was contacted by a purported juror. He said he was able to identify which juror they were from his conversation with them. So this was direct contact, no intermediaries. According to Attorney Jackson's description of the conversation, Juror D said the jury was unanimously agreed that the defendant was not guilty on counts 1 and 3, and the jury's disagreement was solely as to counts 2 and its lesser included offenses. Attorney Jackson submitted a second supplemental affidavit on July 18th. He stated that he had been contacted the day before, which was July 17th, by a purported juror. So, what is this, 5 now? 4? 4. So he again said he could identify the individual as a deliberating juror, including, or according to Attorney Jackson, Juror E said the jury was unanimous on 1 and 3. The defendant was not guilty, and the jurors deadlocked only on the lower charge on count 2. On August 1st, 2024, the Commonwealth filed in the trial court a notice disclosing that on July 21st, an unsolicited voicemail was left on the office phone line of one of the trial prosecutors. So this is where the jurors contacted the Commonwealth too. The caller, who identified themselves as a juror by full name and seat number, stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3." So now a juror has come forward to confirm with the prosecution, Adam Lawley, to say, hey, yeah, we acquitted her. What the heck? That same individual left another unsolicited voicemail for the prosecutor on July 26, stating that they can confirm unanimous on charges 1 and 3 as not guilty. And as of last vote, it was 9-3 guilty on the manslaughter charges. That changed because that particular juror that Turtle Boy interviewed, one of them, he's done 3 interviews, 2 with the same guy, which changed his vote. He was the swing vote. So at first it was 9-3, and then he went back down 8-4, if that makes sense. So he was bullied into changing his vote, and then he changed it back on his own. So that accounts for those numbers there, why the counts keep changing. The Commonwealth's notice further disclosed that it also had received emails from 3 individuals who identified themselves as jurors and wished to speak anonymously. So 3 other individuals wanted to speak. So how many? Okay, I think there's more to this story. How many jurors actually did contact the Commonwealth, and what else did they say? The Commonwealth had responded to the emails by stating that although it would welcome the opportunity to discuss the evidence or its case, it was ethically prohibited, this is a bunch of BS, from inquiring into the substance of the jury's deliberations and could not promise confidentiality, as it might be required to disclose any such communications to the defendant or the court. All 3 individuals declined to communicate further with the Commonwealth and further no information about the jury's purported votes. So basically, the Commonwealth was like, well, we can't really get into your deliberations, and we can't keep you anonymous, so you probably don't want to talk to us. That's basically what they did in order to get them off of the Commonwealth's back so they wouldn't talk. They're like, well, we can't keep your name quiet, so, you're going to have backlash. Commonwealth. On August 5th, Attorney Yannetti submitted a supplemental affidavit stating that he had received an unsolicited phone call. Say the words that are on the page, tongue. He said he received an unsolicited phone call on July 31st. This is now almost 30 days, 31 days from when the mistrial was called. The caller said that they had been a juror on the case, and based on what they represented to Attorney Yannetti to their full name, Attorney Yannetti stated he was able to confirm that the caller was the person identified as Juror B in his prior affidavit. According to him, the caller said the jury had reached unanimous not guilty verdicts on indictments 1 and 3 and had been deadlocked only on the second indictment. The caller also said they were familiar with Attorney Yannetti's prior affidavit, and the text message exchange referenced in paragraph 4 of the affidavit, which is also quoted above, was accurate, except they had meant to write, "No one thought she hit him on purpose or even knew that she had hit him." Meaning, if she did hit him, she didn't know she hit him. So no one thought she hit him on purpose. No one thought it was intentional. So, and if she had hit him, it wasn't intentional and she didn't know she did it. The caller believed the other jurors had been reluctant to come forward because there is so much public and media attention focused on this case. Not just that, but Brian Albert, Jen McCabe, Colin Albert, and Carrie Roberts all sat in the gallery, or whatever you call it, the gallery of the jurors, or I'm sorry, the spectators, that's the word, as the closing statements were given. So they sat there staring on, face like eye to eye with the jurors, staring at them as closing arguments were being given by both sides. So it's kind of awkward. Jury privacy and safety concerns. On July 8th, the same day the defendant filed her motion to dismiss, the trial judge sua sponte issued an order impounding the list of names of the impaneled jurors. So she just, on her own, decided to impound all the jurors' names. The judge noted that the case has garnered significant and divisive attention in Massachusetts and across the nation, and that the proceedings continued to be the daily subject of commentary on various social media platforms. She noted, too, that people associated with the case have been charged with intimidation. Wah wah, turtle boy, naughty turtle boy. He's been charged by the same people that he is accusing of being criminals. So I don't know how much you want to take his charges, to mean something there. She found that there was a real and present risk of personal harm to the jurors and to the integrity of their service if their names were to be made available to the public at that time, and thus a risk of immediate and irreparable injury, injury, establishing good cause to impound the list. The order stated that it would expire in 10 days from its issuance unless otherwise ordered by the court for good cause shown. So, just like clockwork, July 18th, one of the deliberating jurors, represented by counsel and proceeding under the pseudonym Juror Doe, filed an emergency motion for an indefinite extension of the impoundment order. The motion was supported by an affidavit from the juror. Juror Doe averred that they feared for their personal safety and the safety of their family if the jurors' names were made public. In addition to the conduct noted in the impoundment order, Juror Doe recalled trial testimony from at least one witness who had described herself and her family being harassed because of her involvement in this case. Jen McCabe and Allie McCabe throwing in that witness intimidation for good measure. Juror Doe also stated that during deliberations, the jurors could hear protesters outside screaming and yelling, and after the jurors were discharged and transported by bus back to what was supposed to be a secret location, they were met with what appeared to be media members, including photographers. Juror Doe cited recent examples of news articles and social media commentary in which individuals had expressed anger at the jurors, sought to identify the jurors, and advocated publicizing the jurors' home addresses. So this is not even true, but he's afraid that someone was going to be publicizing their names and addresses in order to harass them. In closing, Juror Doe said, "My affidavit and motion should not be interpreted as indicating how I or any other juror voted on this case or how I or any juror feel about the case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large group portion of the public who intensely followed this case. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during the deliberations. It was an honor to serve on the jury. It also was a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny. Ugh, and likely harassment campaigns strictly due to the outcome of our private deliberations. You don't think that being on a high profile case that that's going to happen? Any high profile case, there's going to be scrutiny from the public regardless. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer to not have to respond to these inquiries. However, what I fear is not only what I will be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on that jury. Hold on. Sit down, dog. Sorry. Back here, what I think is where I left off. However, what I fear is not only will I be subject to requests for interviews, but that I will be targeted and harassed because of it, or did not do it on, of what I did or did not do on the jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. Why? At what point in time did he think thing like, uh, yeah, there's no threat of physical harm or violence, and yet this guy is already there and wants his stuff to be private because he thinks that there's some kind of physical harm that he's going to endure. I am not prepared or equipped to anticipate and prepare for any surprise personal attacks. More importantly, I fear that I will not be able to protect myself and my family. The trial judge credited Juror Doe's affidavit and found that Juror Doe had established good cause to extend the impoundment order. Isn't it weird that she did that publicly just to make sure that everybody knew they had 10 days to file a motion to extend the order? So she did that on purpose to make sure that someone would file an affidavit to seal all their names. That's what I think. Summary of argument, and this, I don't think we're going to read through all of it, but let's try to get through some of it. So a trial judge soundly exercised her discretion in declaring, yeah, soundly, okay, in declaring a mistrial on the ground of manifest necessity. The jury repeatedly reported it was deadlocked and further stated that continuing to deliberate would be futile and only force the jurors to compromise their deeply held beliefs. The jury gave no indication that it had reached a unanimous verdict on any charge, and the defendant argued at the time against finding any such unanimity. Um, they argued at the time against it? No, they didn't. I don't. What is he talking about? That makes no sense. All right. There was no viable alternative to a mistrial. Wrong. But even so, the defendant was afforded a meaningful opportunity to be heard. Wrong. On the purported alternative. That's not true either. This is all a bunch of lies. The Commonwealth just lies. It's the trial of gaslighting. Even assuming there was no manifest necessity, the trial judge properly ruled that the defendant consented to the mistrial. The possibility of a mistrial because of a deadlock was clear from the jury's final or first note and clearer still from its second note. Defense counsel consistently pushed for that result in response to these notes, had ample time to prepare for a mistrial before it was later declared, and raised no objection despite multiple opportunities to do so. The defendant's personal assent to the mistrial was not required. The defendant was not acquitted of any charge because the jury did not return, announce, and affirm any open and public verdicts of acquittal. That is because Judge Canoni did not allow them to in her jury instructions. That would be my argument in that. That requirement is not a mere formalism, ministerial act, or empty technicality. It is a fundamental safeguard that ensures no juror's position is mistaken, misrepresented, or coerced by other jurors. It also protects each juror's right to rethink their position and to change their vote before reaching a final verdict. The alleged post trial statements from certain purported jurors do not constitute acquittals, and the judge properly denied the defendant's request for a post trial inquiry of the juries. I think that's incorrect. I think she improperly denied the request. Judges bring in juries for all sorts of reasons. They're doing it in Ashley Benefield. They did it in Murdoch. They're doing it in, I don't know, I can't think, but they do it often. And when situation calls for it. I mean, it's not an everyday thing, but it's not unheard of. So for this to be like, well, we just don't do that because it wasn't said in court, that's a dumb reason. That inquiry would necessarily require delving into the jurors' deliberations. No, it wouldn't, which this court has consistently and firmly held impermissible. The argument: the judge soundly exercised her discretion in declaring a mistrial where the jury repeatedly reported it was deadlocked, gave no indication of unanimity on any charges, and stated the further deliberations would be futile. Wow, a lot of big words there. Double jeopardy principles do not bar retrying a defendant when a mistrial is declared as a matter of manifest necessity. Manifest necessity is another way of saying that in a particular case, the right of the defendant must yield to that of the public. A deadlocked jury is the prototypical example of a manifest necessity justifying declaration of a mistrial. This court accords great deference to the trial judge's determination when a mistrial is premised upon the trial judge's belief that the jury is unable to reach a verdict. The propriety of a deadlock-based mistrial is not answered by application of a mechanical formula. It is a circumstantial inquiry, and the pertinent factors correspond to those informing whether the jury has conducted due and thorough deliberations. And these factors include the time spent deliberating relative to the length of the trial, the complexity. Okay, so this is all just repeat of what they've already kind of said. So here, after deliberating across 4 days, the jury told the judge it had exhaustively reviewed the evidence and diligently considered all disputed evidence, but had been unable to reach a unanimous verdict. Considering the jury's note, the extent of deliberations thus far, in view of the trial length, the amount of the evidence presented, and the complexity of the issues to be decided, the judge found the jury's deliberations had not yet been due and thorough, and she instructed the jury to continue deliberating. On the next day of deliberations, the jury sent the judge a second note. Yes, we know. Considering again the jury's statements and the additional time spent deliberating, the judge found the jury had conducted due and thorough deliberation and provided the Tui Rodriguez charge. Later that afternoon, the jurors returned a third and even more emphatic note that said, "We continue to find ourselves at an impasse. Our perspectives are starkly different, blah, 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 blah." The judge had no doubt, based on the jury's notes to the court, that it was unable to reach a unanimous verdict. It was also clear to her, but it can be interpreted one of two ways. It can be interpreted that they couldn't reach a unanimous verdict on all charges, or just that they didn't reach anything unanimous because she told them not to put down anything until they had a unanimous verdict of all three charges. What they interpreted that as. So it has different interpretations. So even though it was clear to Canoni that that's what the jurors meant, that's not necessarily what it meant. So it was clear to Canoni from the third note that the jurors would not consent to continuing their deliberations. At that point, the jurors could not be compelled to continue deliberating without their consent. In short, the judge's declaration of a mistrial due to deadlock was informed by her consideration and weighing of the specific factors pertinent to that decision. She did not abuse her discretion. Well, you know what she could have done? She could have asked them, or did you reach any verdicts on any of the counts? She didn't ask that. That would have been an alternative to a mistrial. Just saying. So the defendant nonetheless claims the judge erred by failing to consider alternatives to a mistrial and to give defense counsel an opportunity to be heard. As to purported alternatives, she contends the judge should have inquired whether the jury reached a unanimous verdict on any charge or asked the jurors if they would consent to further deliberations. The judge was not obligated to make either inquiry as a matter of course. No, but it is encouraged greatly, as we read in the defendant's filing to the SJC. It is very much encouraged to poll and make sure that you're not calling a mistrial for counts that someone may have been acquitted or convicted on. I don't know why this is so hard for them to understand. They are just backpedal, backpedal, backpedaling. That's all this is putting a band-aid, continuing to just let the wound fester because there's so much rot at the top, including Judge Bev and Mike Morrissey, who, by the way, if you missed my last breaking news story, Michael Morrissey, the DA, now has offenses listed under him for his Brady Giglio. He's got misconduct and all sorts of things, bias, using his abuse of power, blah, blah, blah. And not just that, but Judge Canoni may be out. She may not be the superior judge anymore. Like she's the number one judge. Not after January 1st. Rumor has it. So that's not necessarily confirmed, but yeah, there we have it. Two sources said that. So the circumstances before the judge also did not necessitate either inquiry. There was no reason for the judge to ask if the jurors would consent to further deliberations. The jurors' final note made abundantly clear that they did not consent and that I agree, they wouldn't have probably deliberated any further. And that if they continued to deliberate, any verdicts reached would not have been each juror's own verdict, the result of their own convictions, but rather a mere acquiescence in the conclusions of the other jurors, like how they were being bullied in the end. So there was also no basis for the judge to inquire whether the jury had reached a unanimous verdict on any charge. I disagree wholeheartedly with that. Nothing in the jury's three notes indicated agreement on any of the charges or even an inkling of an indication of agreement. Fine, let's agree and say there was no indication or inkling that they had reached any kind of verdict. So let's say that you do believe that they meant they were wholeheartedly uh, deadlocked on every single count. Let's believe and think that maybe that's even is what it was. But to not ask at that moment and for the defense to say, "Can you at least just bring them in and question them?" At that point, she should be like, "Yeah, let's make sure that we didn't do something wrong here." But no, she just doubles down in the rot and the fester and everything, the gross, evil corruption that's happening there. She doubles down and says, "Nah, we're not going to give Karen any kind of break here. If you want to appeal it, go to the SJC." Come on now. Anyways, nothing in the jury's three notes indicated agreement in any of the charges or even an inkling of an indication of agreement. To the contrary, the first note said the jury was unable to reach a verdict, declaring outright that the jury had not reached a unanimous decision on any charge. That's not the words, no. Unable to reach a unanimous verdict. That doesn't say that. That doesn't say that they were unable to reach a verdict on any of the charges. The second note stated consensus is unattainable, which would be a peculiar way of describing the jury's deadlock if consensus had in fact, been attained on any charge. The third and final note, returned after the Tui Rodriguez instruction, stated that the jury remained at an impasse on the charges, not just a particular charge, as the judge found the only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the three charges and further deliberations would serve no purpose. Moreover, the judge was mindful of this court's repeated admonitions that deadlocked juries are particularly susceptible to coercion. The jurors in this case had reported three times that they were unable to reach agreement and had been given Tui Rodriguez. Where am I picking it back up now? Okay. The jurors also had been instructed on lesser included offenses. The judge recognized that even asking the jurors, they didn't get instructions on how to treat the lesser. I mean, they did, but it was so confusing, and I don't think they understood it because I didn't understand it. The judge recognized that even asking the jurors if they were truly deadlocked, let alone probing on which charges they were deadlocked, would be coercive. No, it isn't. Asking them if you're deadlocked, that's not coercive. That's a yes or no question, by the way. The judge further recognized that to make such an inquiry on her own accord could impede upon the strategic decision of counsel to make such a request. Given that counsel had previously accused her of directing a verdict on the lesser included offenses because of how the OUI manslaughter verdict slip was initially worded, or didn't have check boxes for not guilty, uh, yeah, they thought that she might have been pressuring the jury to reach a certain verdict or to go a certain way. Far from failing to consider an inquiry into the nature or extent of the jury's deadlock as an alternative to a mistrial, the judge was acutely aware of the concerns that would have made such an inquiry improper upon the circumstances. Nor was defense counsel denied a meaningful opportunity to be heard. No one was afforded an opportunity to speak. She didn't even let them see the note. In response to the jury's first note, counsel disagreed with the prosecutor's characterization that the note left open the possibility the jury might yet achieve unanimity. Counsel argued the note could only mean the jury had already exhausted all manner of compromise, all manner of persuasion, and was at an impasse and should be given the Tui Rodriguez. He did not ask the judge to inquire of the jurors what they meant when they said, "We have been unable to reach unanimous verdict," or whether they had reached verdicts on some but not all charges. But that is Judge Cannoni's responsibility when she's about to declare, and if she's about to declare a mistrial, she needs to know that they didn't come to any verdicts on any of the charges. That's her job, not the defense's, I would say, that I would argue. With the jury's second note, counsel argued the jury have come back now twice, indicating essentially that they are hopelessly deadlocked. Leveraging the language in the note, he emphasized that the jurors had fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. He again argued in favor of a finding of due and thorough deliberation, and again requested Tui Rodriguez. He exhibited no curiosity at all about the extent of the jury's deadlock and did not ask the judge to inquire of the jurors. I don't even know if it's proper for him to do so at that point. Is it? Does anybody know? Would it be proper for an attorney to ask where they're leaning in the middle of deliberations? I don't know. The defendant now claims that her attorneys, by requesting repeatedly the Tui Rodriguez instruction, was merely trying to encourage the jury to reach unanimous verdicts. In reality, and as the judge found, counsel were pushing for the result of a mistrial. In reality, and as the judge found. So you guys are just like mind readers, apparently. You just knew that they were pushing for a mistrial. knowing that the judge would not declare one until the instruction had been given, and that if after the instruction the jury returned deadlocked again would be triggered and a mistrial would be all but inevitable. When the jury sent its third and final note, the judge informed counsel in open court while waiting for the jurors to enter the courtroom the jury is at an impasse. Counsel could not credibly have believed that the result of that note would be anything other than the mistrial for which they had consistently pushed, and it can fairly be inferred from counsel's silence as the judge read the note aloud and declared a mistrial that counsel neither objected to the mistrial nor would have suggested an alternative. There was no opportunity. It was blah, blah, blah. I'm reading the note, blah, blah, blah. I'm not going to do that. You're dismissed. That's how fast it was. So I don't know when they could have objected there. Anyways, so even so, counsel still had multiple opportunities to object if they in fact objected. Counsel could have objected or at least asked to be heard on the matter at any point while waiting for the jurors to enter the courtroom after the judge announced the jury remained at an impasse during the subsequent discussion with the judge about scheduling a status hearing or while the jurors were still at the courthouse and waiting in the deliberation room for the judge to speak to them. Again, I want to know what happened while the judge spoke to them. Had defense counsel raised an objection, they would have been heard. Well, maybe so, but she didn't even allow it. It was so fast. It felt very, very rushed. The judge made a point to note that counsel were no shrieking violets. They had never needed the judge to inquire whether they had an objection in order to be heard, and she had never refused them an opportunity to be heard in open court or at sidebar. Okay. Despite several opportunities to do so, counsel raised no objection to the mistrial. Indeed, counsel said nothing about the mistrial to the judge, and after engaging in a scheduling conference in open court before the judge proceeded together with the defendant to the courthouse steps where counsel made statements to the media and onlookers. Counsel's statements also expressed no objection to or dissatisfaction with the mistrial. Rather, counsel declared the Commonwealth failed miserably and will continue to fail. For these reasons, the judge found not credible the assertions in the defendant's motion that the declaration of the mistrial was sudden and unexpected, or defense counsel's assertion in his affidavit that he lacks an opportunity to be heard. The defendant cannot overcome those credibility determinations fully supported by the record, which show the remarkable turnaround in her position post-trial for what it is, a hindsight contrivance based on the purported juror statements. Okay. But the jurors were the ones that come up with the verdict. So, I mean, it's not just purported juror statements. I mean, this is clearly the jury was not given a chance to even express that they had a verdict on any of the charges. So it's definitely Judge Cannoni's error, but moving on. The judge properly found the defendant consented to the mistrial where counsel consistently pushed for that result, had several days to prepare for it, and when it was declared, did not object despite multiple opportunities to do so. I feel like we just addressed this, but okay. A defendant's counsel or consent to the mistrial removes any double jeopardy bar to retrial, according to Pellegrin and the Commonwealth. Such consent may be inferred from silence where a defendant had the opportunity to object and failed to do so. Had the opportunity is the objective phrase there because they didn't have the opportunity to be heard. A defendant's silence in the face of a mistrial declaration has also been held to demonstrate consent when the total situation was such that the defendant could reasonably have anticipated that the issue of a mistrial could arise and could prepare himself for the event. Silence could then be plausibly read as acquiescence. As discussed above, defense counsel consistently sought a mistrial and when it later transpired, raised no objection. Counsel also had ample time to prepare for that outcome. The jury returned its first note around noon on Friday, June 28th, its second note on the following Monday, July 1st, around 10:45 a.m., and its third and final note at 2:30 p.m. that same day. Counsel had 3 days between the first and second notes and several more hours between the second and third notes to prepare for a possible mistrial and to discuss the matter with the defendant. The defendant cites Horrigan for support, but the total situation here was markedly different than in that case. In Horrigan, on the morning of the second day of trial, the first justice of the district court abruptly and with no prior warning to the parties or counsel walked into the courtroom and announced a mistrial because the trial judge had a medical emergency and could not preside. There, the mistrial was truly sudden and expected. Here, it was entirely foreseeable and played out over days. The defendant also argues that her personal assent to the mistrial was required. She did not raise this argument before the trial judge, and it is waived. The defendant was not acquitted of any charge where no verdict of acquittal were returned, announced, and affirmed by the jurors in open court. Again, it's all by design that they weren't able to give their verdict. As this court has explained in rejecting a claim of double jeopardy based on purported acquittals, the only verdict which can be received and regarded as the complete and valid verdict of a jury upon which a judgment can be rendered an is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. Jeez, Lou. I gotta pause here for a second. I'm being summoned by the dogs. Hold on. All right, I'm back. Sorry about that. I don't remember exactly where I left off, so I'm gonna start at the top of this page. I think I was here. All right, so the defendant was not acquitted of any charge where no verdicts of acquittal were returned, announced, and affirmed by the jurors in open court. Again, they're basically saying because it wasn't said in open court, it didn't happen. But that's not necessarily true. That's just what they're trying to say. So, as this court has explained in rejecting a claim of double jeopardy based on purported acquittals, the only verdict which can be received and regarded as a complete and valid verdict of a jury upon which the judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. Well, that's fine. They could have just called everybody back and done that, but they chose not to question it. Just pretend like all these individuals didn't reach out to the defense and the Commonwealth saying we acquitted her. Let's just pretend that didn't happen. Let's just ignore that little fact. It's crazy. The jurors here did not return, announce, and affirm any verdict. Their only open and public unanimous acts were their statements to the judge that they were unable to reach a unanimous verdict or to attain consensus, remained at an impasse, and were starkly divided on whether the evidence was sufficient to establish the elements of the charges. Requirement of an open and public verdict announced and affirmed in court is not a mere formalism. Public affirmation in open court provides safeguards against mistakes. So that is not just mistakes, but also people changing their minds and things like that. So public affirmation, yeah, it's important. That's why Judge Cannoni should have, I get them confused, they're both hateful creatures. Judge Cannoni has, I don't remember what I was going to say. Judge Cannoni basically made it so that they couldn't even affirm. It was her responsibility to ask the question, did you come to any kind of verdict for any of the charges? But since she didn't say that and her instructions were unclear. This is where we're at in this point in time. So it also protects each juror's right to reevaluate their position and to change their mind on any issue or their vote or on any charge. So they could change their votes, yes, blah, 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 blah. As the judge aptly put it, the rendering of a verdict communicates the finality of the deliberations, and its pronouncement in open court ensures its unanimity. But they weren't given the chance to say it in open court. None of the cases relied on because you're not supposed to just talk out of turn, by the way. The court is, um, ruled by the judge, and the only people that should be talking are whoever's attorney's whoever it's their turn to talk. So, and you have to get permission from the judge, like, may I, Your Honor? And then they are allowed to approach. May I approach? Blah, blah, blah. You know. All right, so none of the cases relied on by the defendant holds otherwise. Those cases address criminal proceedings terminated by judicial action, not a jury's determination on the evidence of the law. The defendant's argument proceeds from a selective quotation on those cases, removing the references to judicial action. The omission is significant. With judicial action, double jeopardy principles distinguish between a ruling on the merits and a ruling on procedural grounds. The substance of the ruling, regardless of its form or how it is styled, makes a difference. There is no such distinction with a jury determination, and judicial action does not require the same safeguards that are served by the verdict requirement. Judicial action and jury determinations occur in different contexts. The rule for the former does not logically or necessarily extend to the latter. I don't necessarily think this is a great argument. Even granting the defendant her flawed premise, there were no acquittals here for the same reasons as in Bluford and a juvenile. In Bluford, they love to reference both of these. In Bluford, the foreperson disclosed to the judge that the jury had voted unanimously against guilt on two of the offenses, was deadlocked on a third, and had not voted on a fourth. The jury continued to deliberate, later reported to the judge that it had not reached a verdict, and the judge declared a mistrial. The defendant there similarly argued acquittal is a matter of substance, not form, and that he had actually been acquitted and of the two offenses based on the foreperson's report of the jury's unanimous votes. The United Supreme Court expressed no approval of his premise of substance not form and instead rejected the argument on its terms. Foreperson's report was not a final resolution of anything, the court held, because the jurors continued to deliberate after the report and were therefore free to revisit their prior votes and to change their minds. This doesn't apply. They were done. They were done discussing, they were done deliberating on counts 1 and 3. They didn't write it on paper because they were told not to put down their verdicts until they were unanimous on their verdict, which they thought meant all 3 charges they needed to be unanimous on. They didn't ask the question because for some reason the jury foreman decided he wasn't going to, even though some individuals asked to have that clarified if they could do some kind of a split verdict. And the foreman said, no, I'm not going to ask Canoni that. So there's that too. The court further noted that it would be unjustified to assume the reported votes did not later change, given the possibility that even a single juror could have rethought their position on the offenses. But they all agreed in the deliberation room together as a group that they were unanimous. So at that point, they've reached a verdict. They're not still discussing. And yeah, I don't understand what the problem is and why the Commonwealth just doesn't get common sense and logic. Therefore, or likewise, sorry, in Juvenile A, this court held that the signed verdict slips showing not guilty entries, which were found in the deliberation room after the declaration of a mistrial due to deadlock, did not contribute or constitute acquittals. It was not enough to show that the jury may have agreed on some issues at some time, otherwise, uncertainties would be invited. As the defendant points out, there was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. Same is true of the purported juror statements here. A closer reading of them reveals that they do not identify at what point during the 5 days of deliberations the jury allegedly reached unanimous agreements on two of the charges. As such, they do not foreclose the possibility that the supposed why do I unanimity, it's like my brain just stops working sometimes and I forget. And I've been saying this word like a bajillion times, and all of a sudden my brain just is like done. I don't know how to pronounce you. I'm sorry. Autoimmune diseases suck. All right. So, as such, they do not foreclose the possibility that the supposed unanimity perceived by some jurors were based on a preliminary discussion or straw poll conducted early on in or at the start of the deliberations, the very scenario cited by the Supreme Court as a cautionary example. The trial judge properly rejected the defendant's attempt to bolster their statements with a post trial inquiry of the jurors. I disagree with that wholeheartedly. As it is well settled that inquiring into the jury's deliberations, including a juror's individual or the jury's collective decision making or thought processes, is impermissible. That's not what they're asking. The defendant argues that an alleged unanimous but an unannounced agreement among the jurors should be considered the type of overt factor that is an appropriate subject of inquiry. Okay, where am I? But in Fiddler itself, this court explained that a jury's decision making process, any individual juror's thought processes or mental impressions, the reasons for the jury's decisions, or anything else that intrudes on the juror's deliberations do not constitute overt factors. Mm, 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 mm. The defendant further argues that inquiry should be permitted here because double jeopardy is a fundamental constitutional right. The appeals court rejected a similar argument in Commonwealth versus Di Benedetto, where it noted if that logic were to control an inquiry could be made whether bedrock constitutional rights are implicated, the expectations would swallow the rule. I don't know what that means. Attempting to establish any alleged unanimity reached by the jurors here in the course of their work or of their deliberations would necessarily entail prescribed inquiry into deliberations, although the judge accepted the purported juror statements, which contain two, three, or even four levels of hearsay, are true and accurate for purposes of deciding the motion. The She explicitly disagreed with the defendant's characterization of those statements as being strong and uncontradicted. For one thing, the statements directly contradicted the jurors' notes during their deliberations, including their final note expressing their stark divide as to the elements of the charges. The defendant says the jurors' reference to charges can be readily understood to mean the manslaughter charge and its lesser included charges. They could be, when they say charges plural, it could just mean the manslaughter charge, which has lesser charges in it. So it's feasible that they were talking about charge count number two only, potentially. It's also possible they were talking about all three. It can be interpreted either way. So that is why you need to bring the jurors in. I mean, it's really that simple. And this could have all been dealt with and taken care of by now, but they just don't want to acquit her. And that's the problem. So they're going to have to be forced by the Supreme Court to do it. Where was I? Okay, so that is not the more natural and straightforward reading, nor is it consistent with the defendant's position at trial. For the defense to now claim that the notes were susceptible to different interpretations, such that the court should have inquired further, rings hollow, particularly where Attorney Yannetti has twice argued that the jury had engaged in due and thorough deliberations and could not agree. But more importantly, it does not matter how the defendant now in hindsight interprets it. It matters what the jurors meant at the time and why they said it, which is why you bring them in and ask them. This is the point here. Whoever wrote this motion, that's exactly the point. It's what were the jurors thinking at that time? What did that note mean? And the only way to do that is to call them in. That cannot be determined without inquiring into their thinking and deliberations. No, false. This is false. You're not getting into the substance of their deliberations. You're asking, well, what was your verdict? Was this your verdict? It's not that difficult. As another example, according to Juror C, the jury was this is the one I think that had the affidavit and the lawyer and went to the Commonwealth with their filing. As another example, according to Juror C, the jury was unanimous only as to second-degree homicide, and the remaining charges were what they were hung on. Apparently, even the 5 purported jurors, to say nothing of the 7 other jurors, were not of one mind. Though, but okay. These and other discrepancies would need to be reconciled to establish with any confidence whether in fact or to what extent any unanimity may have been reached, and that would require an impermissible inquiry into the jury. It's not impermissible into their deliberative process. It's not in the deliberation process either. They're just bold-faced lying to the Supreme Court. Additional considerations militate against the requested inquiry. Jurors questioned at this point more than 3 months after they were discharged. You guys did that on purpose because you let it drag out. Judge Canoni let it drag out 4 months because she wouldn't decide, she wouldn't give an answer. These affidavits and things were flying in right after trial. She should have dealt with it immediately instead of waiting this long. But now they're going to use that as an argument. It's their fault that it's taken this long, but now they're going to use that as an argument like, well, we just can't ask them now because it's just too late. Sorry. Jurors questioned at this point, more than 3 months after they were discharged, may feel pressured to provide responses that they believe will minimize their risk of being harmed or harassed. As described in the judge's order impounding the list of the jurors' names and in Juror Doe's affidavit, people associated with this case have been charged criminally with witness intimidation. Charged, not convicted, and charged again by the criminals that are locking up innocent people and framing them for homicide. Individuals have also expressed outrage at the jurors and sought to identify them and release their personal information for the purposes of harassing and shaming them. Juror Doe said they fear for their personal safety and that of the family, and they worry that they will be subject to harassment or even physical harm because of what they did or didn't do on the jury and what the outcome was of the jury deliberations. Several of the purported jurors also wish to remain anonymous. The concerns are forward looking as well. The proper evidence of the decision of the jury is the verdict returned by them upon oath and affirmed in open court. It is essential to the freedom and independence of their deliberations that their discussions in the jury room should be kept secret and inviolable, like can't be violated. And to admit the testimony of jurors to what took place there would create distrust, embarrassment, and certainty. If jurors' deliberations are allowed to become the subject of post trial inquiry because of purported statements like those here, future jurors may be hesitant to express their views fully and honestly during deliberations. It also may be more difficult to find jurors willing to serve both in the retrial here and in other cases when jurors know their service may not end when the trial ends, but they could also be subject to further inconvenience, embarrassment, or harassment well into the future. I don't think that's a good reason. That's not an excuse not to be or not to bring them in to ask them questions on what their verdict was, if any. Conclusion: for these reasons, the Commonwealth respectfully requests that this case be remanded to the county court for entry of a judgment denying the petition. F you, buddy. It is signed by Caleb Schillinger. I don't know. He must be the appellate attorney. And then you've got Adam Lally and Laura McLaughlin on there as well as a copied Michael Morrissey. So, yikes. That one, there really wasn't a lot of new argument. The only new thing that I'm hearing is though, oh, well, you guys took too long to bring them in, so now we can't do it, even though it was Judge Canoni who refused to bring the jurors in to inquire. I don't think that it matters. I think, didn't they do in Murdoch? It was like a year later they brought in the egg lady, or not the egg lady, but they brought in the jurors to ask them if Becky Hill had uh, somehow influence them or talk to them out of turn, if she had said anything, because she was reportedly saying things like watch Alec Murdoch, um, and certain things like that, like watch him on the stand. This is unprecedented that a defendant gets up and takes a stand in their own defense, and things like insinuating that he wasn't going to be truthful or honest. And that's how people took it. Yet they didn't overturn. So I don't know. Like, that's a whole nother story. But still, that was like a year later, almost, I think, for when they brought the jurors back to ask them. So there's no reason why they can't. What happened in that deliberation room, you can't change it. So whoever's going to come on the stand and tell what their verdict was, if they're lying, they're lying under oath. They're not going to just change their answer just because they're afraid of little Colin Albert, with his busted up knuckles because he falls on his knuckles when he slips on ice. Can't make this stuff up, guys. Yeah, so uh, that is where I leave you for today. Hopefully, we get some kind of. We are going to have arguments. I can't remember when the date is. I think it's in December, where they're going to have arguments with the SJC to argue these briefs, and then it's going to take some more time after that, I'm sure, for some kind of a response from the SJC, probably a couple months out from now. But they need to come up with something because January is looming around the corner and that's when trial starts. So they need to probably act on it sooner rather than later. But will we get it before Thanksgiving? Probably not. Hopefully before Christmas. That's what I would say. Some kind of answer, hopefully before Christmas. That's what we could hope for. It's already October. I mean, it takes a while for them to even just type up their briefs and stuff. So hopefully we get some kind of response soon, and that response includes dropping the charges 1 and 2. Not just dropping them, but officially saying Karen Reed is acquitted on the record, and then they can't come after her again for those charges. So that's ideally what we want. All right, guys. Well, let me know what you think of the Commonwealth's brief here. I think I don't think they have really good arguments, and they're not very strong. It's basically the same things that we've heard from them over and over again, saying that, oh, it's the deliberative process. We can't get into it. BS. That is BS, if you ask me. Let me know what you guys think. Please don't forget to hit the like button on your way out. And I will see you guys in the next one. Take care. Bye now.